Nobody knew it in 2016, but when Ginger Mooney appeared as Abdulrahman Noorah's lawyer in the hit-and-run death of Fallon Smart, she was already a pro at representing the particular needs of Saudi students facing criminal charges in America. The problem was, many of those students had fled the country before trial or during their probation, some of which have never before been reported upon. While a single client's disappearance is not necessarily a reflection on an attorney, a whole bunch of them is, especially if they form a discernible pattern. And Mooney sure did, particularly when you look at bail and passports.
You know, I don't I don't believe that the person who killed my daughter will ever stand their day in court at this point. But I would, and I'm really appreciative of the efforts of like Senator Ron Wyden to try and take steps to, make sure the Saudi government is acting properly. But I'm more concerned with the people here in our justice system who aren't acting ethically, who aren't doing their job, who are allowing for um, people like Mr. Noorah, whether he did it or not, and these other Saudi students have, been accused of committing crimes, like that they're not being held accountable, that people aren't investigating fully, that they're not being prosecuted completely. I think it's very disheartening to say the least.
Aside from handling a few civil cases earlier in her career, Ginger Mooney chiefly represents poor criminal defendants and maintains a state contract for that work. Oregon is the only state that manages its constitutional obligations to needy defendants through such a contracting system, yet it also permits those lawyers to work for paying clients. It's a bizarre arrangement because the state cannot track contractors' actual workloads, unless you manually look up their cases and create a spreadsheet, like I did. For the first decade of her career, Mooney picked up 228 new cases, split almost evenly between post-conviction relief or habeas corpus and criminal. In her second decade of work, Mooney took on 303 new cases, but she had veered dramatically away from criminal defense. In 2014, Mooney also started representing paying Saudi clients in active criminal cases. Those defendants accounted for an increasingly higher percentage of the dwindling number of criminal cases she took on. I couldn't confirm the nationality of one client, but given that his case was all the way down in Lane County and because he had privately retained Mooney, it's a near certainty that he is Saudi. There was seemingly nowhere Mooney wouldn't go for these clients, including counties to which she didn't usually go and counties to which she had never before gone. One of the client's cases was removed from state to federal criminal court, and Mooney followed him there. She had never before appeared in federal criminal court and has never since then. Because Mooney simply materialized in all these unrelated cases for paying clients spread out all over the state, it's certain that she was on retainer for the Kingdom of Saudi Arabia, to go where needed and stomp out fires. Mooney's very first Saudi client was Othman Mohammed al-Arani, charged with sexual abuse and attempted rape. He posted $52,000 self-bail using a check from the Saudi consulate. Eventually, he pleaded guilty and was sentenced to 4 months incarceration. After serving that time, he and his passport were released into Mooney's care. She quickly put him on a plane to head back home, which was a term of his probation. His bail money was refunded to the Saudi consular. The end. I'm using this case as a baseline because it showed proper handling of a passport and honesty about who actually paid bail. Staff at the court did their job and nothing weird happened. Another baseline is a Saudi student case that Mooney was not involved in. Ali Hussein Alamud was charged with rape, sexual abuse, and assault. He paid a $65,000 bail using funds from the Saudi consular, and 2 weeks later, he disappeared. The court then did what it was supposed to do when a defendant flees, of any nationality. The court sent him a bill for the unpaid bail. The Oregonian, which first identified this pattern, named this as the earliest case, but there's an earlier one, and we'll get to it. Coming back to Mooney, her second Saudi case did not go as smoothly as her first. Waleed Ali Al-Harthi was charged with 10 counts of encouraging child sexual abuse. A consular staffer came up from Los Angeles and personally paid the $50,000 bail at what was likely an uncomfortable meeting. Al-Harthi surrendered his passport to the court. Shortly thereafter, Mooney moved the court for its release as his only official identification so that he could register for classes. The court approved it, and then Mooney returned it. 2 months after that, Mooney moved again for its release so that Al-Harthi could travel out of state for testing relevant to his defense. Mooney filed that motion the very day the testing was scheduled, which was quite a dice roll. Again, the court approved it, and Mooney allegedly returned the passport. 4 months later, Al-Harthi fled. The court tells me that they still have his passport, which is interesting, given that TSA tracked him on a flight from Mexico City to Paris, apparently traveling under his own name and using his own papers. After his disappearance, Mooney and the DA argued about whether it was discretionary or mandatory that the court send a bill for the outstanding bail. Mooney submitted an exhibit that did not match the bail receipt in the court file, lacking the address of the person who paid it. So instead of showing that a Saudi royal consular staffer had paid bail, Mooney's exhibit showed that some rando with an Arabic name had paid it. Possibly because of that deceptive exhibit, Judge Matthew Donahue went against statute and refused to send a bill, even if that bill was purely symbolic with no chance of ever being paid. While that was going on, another Saudi student was arrested. Abdulaziz Hamad Aldawais was charged with first-degree rape and other counts of sexual abuse. He was looking at a substantial sentence if convicted. Aldawais was briefly represented by another attorney, and at his arraignment, Judge Sally Avera and Sheriff Deputy Scott Eastland discussed bail.
Good afternoon. This is Judge Avera in Polk County Circuit Court 4. Because several of these matters are ballot measure 11 offenses, the bail has been scheduled at a very high rate. Deputy Eastland, can you tell me how high the bail is on these matters?
I show up $4.5 million, Your Honor.
$4.5 million has been described to me as not just outrageous, but also unconstitutional. And everyone knew that, especially Judge Avera. Although she had been a judge for only 2 years, she had been both a public defender and prosecutor during her 30-year career. Even more unusual was that a judge asked a sheriff's deputy how high the bail was, as if the sheriff was in charge of setting it. Then Mooney appeared. She tried to talk Judge Avera down to $100,000.
All right, Ms. Mooney.
Yes, Your Honor, we would argue that the $4.5 million currently set as the security amount is excessive in light of Article 1, Section 16 of the Oregon Constitution. We'd further argue that under Oregon Revised Statutes 135-265, that the security amount set at $100,000 would be reasonable enough to ensure that he would appear at all further court appearances. Now, this is a significant amount of money for Mr. Aldawais. He is here on a student visa. He has no ability to work, no ability to earn any income. He's completely reliant on a small scholarship that he receives every month. So, again, $100,000 security release is a significant amount of money for him and would ensure his appearance at all future court appearances. We'd further argue that he is prepared to surrender his surrender his passport to the court. We have his passport here today and can surrender that to hopefully ensure that he's not going to leave the United States. He simply will not be able to leave if the court has his passport.
I will reduce the bail, but I'm not going to reduce it as far as you would like. I'm going to reduce the bail to $500,000.
A consular staffer again came up from LA to personally pay bail, and Alduez was released. And he fled the country at nearly the first opportunity to do so. At the hearing Alduez didn't show up to, Judge Avera curiously did not order the bail money forfeit. As a comparison, here's a contemporaneous court order from a different case in Polk, also in front of Judge Avera. She checked the correct box after the defendant took off. In Alduez's case, she did not. In that other case, the court quickly transferred the bail money to the state, as is mandatory. But in Alduez's case, Polk Court never released it, and the money is still unaccounted for. Knowing that, Judge Avera's $4.5 million ask sounds a lot like a shakedown, as though everyone understood that a sizable chunk of money was about to be left unattended by a wealthy Arab monarchy, if only they could just agree on the dollar amount and get the kid released from jail and on a plane already. It particularly sounds like a shakedown when you hear about a Polk case from 3 years prior, that of Saudi student Mana Sultan Monif, the earliest case we found. He fled before his trial for 6 counts of encouraging child sexual abuse. His bail was never released to the state either. Polk officials apparently understood what to expect when Saudi students came to court and knew to negotiate a good payout. Oh, and one of the judges in Monif's case was Fred Avera, Sally Avera's ex-husband. Then there's the case of Adel Ataya Al-Jani, who is charged with online sexual corruption of a child through a police sting operation. He quickly pleaded guilty, and Mooney asked the court for probation rather than incarceration because there was no actual child victim, and because the defendant had a wife and infant triplets to support. Mooney's sentencing memorandum summarized Saudi culture and family honor. Incarceration would have been devastating for them all. Judge Mustafa Kasubai agreed that prison would result in disproportionate punishment for the man. But 5 months into his probation, Al-Jani rewarded Judge Kasubai's empathy by violating the terms of his sentence and fleeing the country. And while we're talking about Lane County, 2 of Mooney's other Saudi cases there were dismissed because prosecutors suddenly decided they could not prove them. In one, a domestic abuse case, a crucial witness left the country, presumably the victim, who was also Saudi. That brings us back to Multnomah County. 8 months before Abdulrahman Noorah ran down Fallon Smart, Mooney had another hit and run to deal with. While impaired, Suleiman Ali Algawez had seriously injured a pedestrian. Even though there was no fatality, bail was initially set higher than the bail first set in Noorah's case. Law enforcement also recommended that Algawez not be released before trial because of disturbing remarks that he and his brother had made to the release officer, indicating that he would flee the country at the first opportunity. Bail was finally set at $300,000, which his sister paid, but was marked self-bail. 5 months into the case, the DA offered him a generous deal, but warned that the offer would be rescinded if he picked up any new charges. A week later, he was taken into custody for violating his release conditions. That should have taken the DA's sweet deal off the table, but no. Algawez quickly pleaded no contest to severely injuring someone while impaired and then speeding off. And Judge Adrian Nelson sentenced him to just 90 days in jail, rather than the presumptive 16 months. Just a few months after his release, while on probation and with his passport in hand, Algawez was gone. But what does his passport even mean when the entity that paid bail and Mooney's retainer, and which has a clear interest in the outcome of these court cases, is the same entity that literally manufactures Saudi passports? More importantly, do they even check passports on the fleet of medevac planes run by the Saudi Ministry of Defense? The fleet which is regularly permitted to land at American airports.